Good afternoon, and welcome to Top 5 Mistakes That Could Doom Your Startup. First thing I want to do is thank Rob and Idea to IPO for sponsoring and organizing this event. We do one every month or two, and it's always great to be working with him. He has lots of other events. I encourage you to uh, look and see all the other kind of interesting stuff that Idea to IPO presents. My name is Stephen Colby. I am a patent attorney. I have been working with patents about 30 years, of which the last 24 or so has been working for a law firm. I am an inventor. I have about 40 patents of my own. And through most of the 90s, that's the 1990s for you young kids, um, I was the CTO of a chemical instrument company, building chemical instruments, selling products, doing engineering, design. That's what my background is. I have a PhD in analytical chemistry and chemical physics, and I'm a partner at Ramon Law. Ramon Law is a semi-virtual law firm, meaning that we have physical offices, but most of us work at home. Uh, the offices usually consists of conference rooms and staff. It's a great place. I split my time. Mostly I'm in Reno, Tahoe area, but also it happens today I am in San Francisco. So I split my time between Silicon Valley and Tahoe. That's it. My talk today is going to be directed at early stage companies. For example, a startup that is looking for venture funding, right? Most of my clients are early stage startups. Some of them have gotten bigger. Facebook is an example, which has gotten a lot bigger since they were an early stage startup and I started working with them. But I do just about everything. I don't do biotech. Other pure DNA or mRNA viruses and stuff like that. We have other patent attorneys at Ramon that do that type of stuff. So we cover all the technologies you can imagine. My practice is heavily focused on software, um, material science, everything from wearable devices to apps to uh, chemical extraction of plants. Let's see, fun things I'm doing today. And this afternoon, I'm going to be working on a project that is a wearable device for breast cancer detection. And I'm also going to be working on a company that does drop shipping for e-commerce. That's the kind of stuff that I do every day. I love being a patent attorney. Ramon is about 225 attorneys around the world. We are in 12 different countries. We are a full service law firm, everything from wills and trusts to patents to aircraft leasing to oil exploration to white collar crime, right? If you have a friend who needs that. So, uh, okay, let's get on with the top five mistakes that could doom your startup. All right. And after 25 years working for a law firm, I have seen just about every one of these mistakes more than once. And I have seen them completely kill a startup. Even after people have invested millions of dollars in it, somebody has made a mistake, somebody wasn't paying attention. My goal here is to educate you in the next hour or so. I will be talking for roughly an hour, and then I will take questions for about half an hour. I will have a hard stop at 1:30. Otherwise, I go all afternoon, and yeah, that doesn't work out too well. Okay. Oh, one thing. Um, if you reach out to me afterwards, I will send you a link to my webinar on how to understand a patent. Um, if you can guess where this background is, I will send you two links. All right. um, no, I'm joking about the two links, but try to guess where this background is. Let's see what else we're going to do. Okay, let's dive into the mistakes, right? Is that done for the intro? Okay, let's close this and let's move on. Boom. Hey, here's the mistakes. Drum roll. Okay. Ownership and ownership twice. I can't emphasize this enough. I intentionally put it both as number one and number two. And in a minute, I'm going to show you why it deserves to be there twice. Okay. The third mistake we're going to talk about is waiting too long. Like, oh, we've been in business for a year and a half, and we thought we might try to do some IP, and too late, folks, right? Number four is no strategy, and this is particularly, I'm going to talk about the importance of IP and why it's actually useful for you for early stage startups, ones that are trying to raise money or have a good exit, so on. And number five is understanding the patent and what rights it actually gives you. That will kind of be, I do the whole webinar on how to understand your patent um, on that fifth point, right? And that's a very useful thing. Anybody who's going to be managing outside counsel or doing IP or considering adding patents to your assets. And again, if you reach out to me after this webinar, my LinkedIn and my email are going to be posted again on the last slide. I will send you the link to that event. Okay. After I finish talking, I will first look at the Q&A tab, right, for questions that people have asked me. And I will go through that, and if I have time, I will look at the chat, but otherwise I'm basically going to be ignoring the chat. I don't have time to look at that while I'm talking. But questions should go in the Q&A tab, and I will try to answer as many questions for you as possible. All right, that's the 5 mistakes. Let's now go through them one at a time. All right, click on the right button. There we go, ownership, all right? In the US, ownership in an invention starts with the inventors, okay? This means that it could be your employee, it could be your co-founder, it could be your admin, it could be sales guy, whoever is the inventor gets the initial ownership of the patent. And inventorship is very strict. It has to be somebody who conceived of an idea that's claimed in the patent application, right? So changing the claims could change the inventorship on a patent application. That happens sometimes. It's important to make sure that you as a company get ownership rights of that, right? And there's a process for patents. Just like when you buy or sell a house in the United States, there's a recording system for your house at the county level, typically, right? There's a county recorder's office that keeps track of who owns what land, right? What houses are on it, what taxes should be paid, all that kinds of stuff. Well, the same type of thing happens with patents. At the USPTO, the US Patent and Trademark Office, there is a recording system that tracks ownership of patents. So if there's an issued patent, you can go and look up who owns it quite easily at the patent office, right? There's also an assignment process, okay? There's certain types of documents with certain types of language, right, that has to be included in order to do a proper assignment of an invention. Now, if you're founding a company, the first thing you're going to want to do is look around at your co-founders or at yourself, okay? You might be bringing in ideas that could be potential patents into the company, right? So typically what you'll have is a founders agreement of some sort or some agreement between the founders, and all the founders will agree to assign their inventions to the company, typically in exchange for some shares in the company and so on. You want to make sure that happens. If it doesn't, what'll go, you might get some investments, but soon there will be an investor that says, hey, you've got these patent applications, but I don't see any assignment of the inventions to the company that I'm going to invest in, right? A good investor will check that and want to see that all the assignments have been made, right? And I have seen cases where a company has raised over $10 million and all of a sudden somebody realizes the CTO never signed their documents, right? And the CTO decides they want a third of the company in exchange for signing that, right? And the company's dead on arrival. And lawsuits, right? They're going. People are getting sued personally, and chaos, right? All of a sudden, the company's definitely dead. So you don't want to be that company, right? You want to make sure all these things are taken care of. And everybody you work with should be subject to this type of assignment agreement. It can be part of a consulting contract, right? That the things that the consultant develops specifically for the company in the company's line of business are going to be assigned to the company, right? It should be in every employment agreement, right? My favorite example is uh, Adobe Forms, right? It's something we all use all the time. It's really useful. Being able to get an Adobe document that is a form and fill it out. That was invented by a sales guy at Adobe, right? So it's not just your engineering team that should be subject to this. I have no idea whether that sales guy got paid a little extra for this invention or not, but Rob is trying to contact me. I don't know what this is about, but hold on. Our host, Rob, is saying, okay, not important. All right, skipping to Rob. Don't send me more stuff, Rob. All right. Um, so the uh, where was I? Oh, assignments, right. You want to make sure everything's assigned, including among the co-founders, your consultants, your contractors, and your employees, right? All your advisors. Okay. Um, in some cases, those agreements might be very narrow, only specific subject. So, for instance, if you're hiring an engineering firm to do development of your software, they are going to be reluctant to sign a really broad blanket assignment because they use the same tools, for developing software for lots of different entities, right? They will probably demand that any assignment they do be very specific and within the work project, the project requirements for a specific thing. All right. Um, and somebody's asking me a question. Yes. I promised I wouldn't look at the chat while I was talking, but I'm going to just, the thing is I have my driving glasses on because my computer glasses had a oopsie. So, all right. That's why I keep bending over, right? Because I can't quite see the screen that well. Yes, there will be a copy of the slides and this is being recorded. A copy of the recording will go out to everybody who registered, whether or not you attended um, live. Thank you. Let's see, next thing. So the assignments have to have specific languages. If you listen to my seminar on understanding the patent, you will see that patents can have families. They can have daughters, right? So if your co-founder sends you an email and says, "Yeah, I promised to sign this invention to a company," that's not quite enough, right? You want specific language that extends to further daughter applications, continuations, divisionals, foreign equivalents, all this kind of stuff. There's a couple of key paragraphs you want to make sure that's in an assignment and in the uh, the agreements, the employment agreement and contract agreements. So it is best to consult a IP attorney on making sure you get exactly the right language, right? Otherwise, you can be a big co. Okay. Those people will sign those agreements, and then your patent attorney takes those agreements and records them at the patent office, right? And that gives the whole world official notice that there's been an assignment made. And there have been some classic cases where people didn't do that properly. Um, let's say a big major Silicon Valley university, I won't mention which one, uh, right, had a professor who assigned to a company and the he had a duty under contract to sign to the university, right? But he made the assignment to the company, and that assignment was good. The university lost out. The university's remedy is to sue the professor, right? Not get the assignment back because the university's rights hadn't been properly recorded at the patent office. So you have to follow these rules and do things the right way. Otherwise, you can run into all kinds of troubles. If you are working for a large entity like a university, you have to keep them in mind. Okay. One of my favorite cases in my field, mass spectrometry, which is a field of chemical instrumentation, there was a very famous professor at Yale that invented a new technique. And it was very powerful. It was very successful. He founded a substantial company that, again, was very successful, right? He ignored the university's rights, right? When you're a professor, you sign an agreement saying that you'll get some royalty usually, but you will work with the university and they'll get a cut of what you do because you're using their facilities and so on to develop inventions. He ignored that. And the university didn't catch on until he made his fatal mistake. He won a Nobel Prize for it. Okay. Then the university noticed, finally. Okay. And they came after him and they got the entire company, right? He lost everything. It was a disaster. This is smart people doing dumb things. Okay. So if you work for a large US company or a large foreign company or a university, you need to keep in mind that you've probably signed certain agreements that give those entities rights to your inventions. Okay. So that's the first step of owning your own IP. You want to make sure your company has rights to its own intellectual property. All right. The second mistake, click, go. Okay, good. The second mistake is other people's IP. All right. So there's a lot of inventions out there. If you think you're the only person doing something, you're probably wrong, right? Certain development of certain technology reaches a critical threshold, and so you get people to inventing things. Um, multiple. What's going on here? All right, excuse me for a second. I'm going to close the chat. Hold on. All right, we have some clowns, so you can no longer chat with each other. So sorry about that, folks. The um, where was I? As a startup, my point of view is that you want to know what else people are doing. And as a former scientist, I was taught to read the literature. And this means going out and going to Google Patents and looking at what other people are doing, right? If you work for a big company, they don't want you to go do this because when you learn about a patent, it increases the liability of the company for being sued and damages. Okay, so if you work for a U.S. semiconductor manufacturer, you don't want your employee, you don't your employer doesn't want you going out and finding patents that you might be infringing, right? But from a startup, it's a different point of view because the large semiconductor manufacturer has a roadmap. A product roadmap. They can't change their products on a whim, but the early stage startup can, right? If you're an early stage startup, you've done your background research, you know what other people are doing, what things have been filed, you can turn 90 degrees and go do something else. You can adapt and engineer around somebody else's IP. You can potentially license it. You can patent around your competitor, right? So just reading the patent literature is likely to give you more ideas. You go, I could do, we could do what they're doing, but better, right? If I took their ideas and my ideas and put it together, I've got something really fantastic. And by the way, I'm going to go patent that before they do that combination, right? So blocking the competitor. Right? This is why I think it's generally a good idea for startups to just pay attention to their competition, put Google alerts on them, see what they're publishing, see what patent applications they have published. So read the literature. And I do have to warn you that when a patent application is filed, it doesn't necessarily get published, right? If you're filing only in the US, you could keep it from getting published for years until it actually issues as a patent. And this means there's quote unquote secret prior art. There's things that people have filed that haven't yet been addressed or haven't been published. And you may not know about it. They may have a filing date that's before you and may pop up in a year or two to be a big problem. You can't know that. That's a problem. That exists. That's an error. Outside the US, things have to publish and usually within 18 months of the first filing dates. So the unknown prior art is limited. This also means that doing searches is limited because if somebody filed something last week and it's not going to publish for 2 or 3 years as a patent, you may not know about it. Even you might hire a search company. They can't find it because it's still secret until it publishes. Right? The next thing that I want to talk about with respect to other people's IP is for you to keep good records, right? The best CEOs, the best founders that I work with, they all have a handy notebook. I don't have one next to me. Sometimes they do, but wait in this drawer. No. Okay. They have a notebook that they write. They come to a meeting with me and they're writing down everything I say and what other people are talking about. So they have a record of the meeting. And 6 months later, they refer back to me and said, "You said this, blah blah." Okay, okay. Um, keep notes of your meetings, right? Keep notes of when you and your co-founders have ideas. So you write down an idea, you put in your notebook, blah blah blah. I had an idea on this. I talked with these two people about it, so on. This is very useful, um, especially because you're going to lots of meetings and you're not going to remember stuff 8 months, 9 months later. Okay. Let me give an example, a real world example. You and three other members of your engineering team are discussing a bunch of ideas, and it's kind of a group think thing. And two of the people in the meeting are chatting back and forth, and they come up with a cool idea. Great. You write it down in your notebook, and you've got a recording system. You make a copy of it and put it on your web archive or whatever in your corporate notes. 3 months later, you hire somebody else from a competitor, right? 6 months later, the competitor sues you for trade secret misappropriation on that idea that you had 9 months ago, okay? And they say, oh, you hired this employee away, and he had this idea with him, and he told you about it, and it showed up in your product, and we're going to crush you, right? Well, you have your notebook, right? Which is very good evidence, and that you and other people developed this before you hired the guy or gal, right? And that's going to turn a multi-million-dollar lawsuit into maybe a $50,000 lawsuit, okay? Which is the difference between killing your company and not killing your company. So keep good notes, keep good records. What if you guys have a meeting and lots of ideas are bounced around, decisions are made, and then 6 months later you're saying, well, who is the inventor on this? We got to figure out the inventorship. And two or three people we can't quite agree, or the memories are fuddled up. Well, fortunately, everybody has their notes, right? Oh, Sue came up with this idea, and Andy added to it to come up with this. Boom. Now they are the two inventors around this path. Okay. Keep good notes. Right? It protects you from other people's IP. It makes your job easier. It lets, as a person who with a lot of balls in the air, right, as a founder of a startup company, it's really great to be able to go back and look at your notes. Right? The final thing on other people's IP is the open source trap. The open source trap is uh, using open source software in your products, right? And while this is possible and it's okay, you have to make it very clear to your employees that your attorney has to review the open source license before they do this. Some open source licenses are very forgiving. Here's our stuff, go use it. All right. Some of them say, oh, here's our stuff, you can use it, but not in a commercial product. Or here's our stuff, you can use it, but you have to make your own product open source, right? And you have to publish all your code. Right? So if you're a company, you don't necessarily want to, who's trying to make a profit and sell a product, you don't want to, publish your code, right? A great example of this is a former and current president of the United States who had a company called Truth Social, right, which is a competitor to X, and they fell into this trap. They used a lot of open source code, right? That open source organization turned around to them and reminded them that they were now required to open um, uh, their entire code base, right? They had to pull the app off the app stores, and it took them months to come back up, right? Because they had to rewrite all this open source code. Don't do that. And be careful about engineers coming from other companies and saying, oh, I wrote this code in my last job, so I'm going to actually be able to take the week off and just, use the same code again. And people think I did a lot in just a week, right? Um, their agreements have to be very clear. They can't do that, right? Because if somebody else finds code that belongs to them in your software, the penalties, the legal consequences can be really dire, right? Okay, so let's moving on now. Um, Hold on. Just give me a second here. Let me bring my things back up. I lost my window. Okay, let's just move on to the next slide. Okay. When do you want to start on this? Let me check the time. Okay, halfway through. Um, uh, when do you need to start thinking about IP? Yesterday, all right? You want to get this done. Um, uh, yeah. You want to get this your IP filed as soon as possible. And hold on, give me just another second. I gotta clean stuff up. All right. Um, so we've got to go. Uh, when you need to start thinking about IP? Yesterday. And the goal here uh, is to get IP done as soon as you can. You want to file at least provisional patent applications as soon as possible. In most of the world, it's a first to file situation. In other words, if you get your patent application filed before somebody else, you win. Okay. If you get uh, if somebody else files a week before you, they might win, right? So it's first to file, no longer first to invent. All right. Getting initial filings can be relatively inexpensive. I'll talk about that in a little bit. Okay. We have something in the US called a provisional patent application, and this can be just a few $1,000s to get something on file, get first priority dates, and it can be the difference between making and breaking the company. I have seen situations where I've had clients and competitors file within a week of each other. And that difference can mean one company really is going to rule the other one, right? It can be devastating. So file as soon as you can. All right. It can be done relatively quickly. For patents, it should be done soon as possible. Trademarks are not quite so critical. Talk to your IP attorney about it and what you can do just to get common law trademark rights using the little TM symbol, right? And so that's the time to do it. Talk to your patent attorney. Should be one of the first attorneys you talk to, right? Even just as you're founding the company, because you have to deal with things like the early assignments. What are the founders going to do? Do they, contribute their IP and then vest for some more such shares, things like that. Your IP attorney can help with all kinds of stuff like that. All right. So file soon, file early. Okay. The next big mistake, strategy. Okay. Um, uh, IP filings and patents are going to be an asset of your company. So why are you doing this? All right. You're doing this to make your company more valuable. Why would an early stage startup with just a few $100,000 in the bank hire a patent attorney? The goal is that the investment in the patent attorney is going to pay back really well, right? You are going to have a much better valuation at every time you raise money, and especially on your exit. I have seen cases where the IP portfolio made a huge difference on whether a company was going to get a good exit or not. And I'll give you that example in a couple of minutes, right? When you're deciding what to patent, the trick is to focus on what's important to your customers, right? Not what engineering thinks is key and important. It's what sells the product. Let me give you an example. You're telling investors that you're going to be the next unicorn because of these three features, these three magic bullets that are going to make you a fantastic company, why you're going to be the top of the world, okay? Why you're going to trump the competition, why people are going to come screaming to your door and buy you. Those features, right? Those are the things that your marketing and sales team talk about when they're trying to sell your products, okay? That's what you want to cover in the patents. So, right? Patents are about inventions, though, not features. So you got to look at those features, discuss it with your patent attorney, and say, This is the thing that's important to us because it's important to our customers, right? This is what our marketing people are going to be pushing. And your patent attorney should figure out how to cover that, right? By patenting certain parts of your technology, right? The parts of your technology that enable these features, right? So your patenting strategy should look an awful lot like your product roadmap, right? And your focus should be on what kind of patents can I do that will make my exit better, right? So for example, if I'm a entertainment tech company and I want to be bought by Sony, right? I might discuss this with my patent attorney and say, it could be that in 4 years, we're in talks with Sony about an acquisition, right? Or a bunch of other companies. These are our hopeful exits, right? And the patent attorney should say, okay, let's think about what their product line would look with your addition, with your technology added to it, right? It would look like, um, and then write patents, claims directly on that, right? So that a few years later, when hypothetically Sony comes and looks at your patent portfolio, they go, oh my God, yeah, we are going to use this company to do this. And they have patents covering their stuff, but also their stuff integrated with what we're going to do, right? Dead on. And then, you know, Sony or a big company like this is going to have the possibility of, are we going to buy this company or are we going to put 100 engineers on this and redo everything they've done in 6 months, right? What's the cost analysis? We're on a spreadsheet. How much is this worth to us? And if the patent portfolio looks good, it can make a really big difference. Probably the most extreme cases I've seen with this is when there are multiple uh, companies that might be bought in the same space, right? And a big acquirer, right? Uh, the Microsoft, the Google, the LG or Sony or Ericsson, who knows, right? And they might look at, part of their decision about who they're going to buy can be like which patent portfolio is better, right? That's not everything, of course, but it's one piece of it. And I have seen cases where the patent portfolio made a difference, and my client got bought for hundreds of millions, and the competitors went out of business, right? Didn't get anything. And it was because of in part, the quality of the patent portfolio, part because my client was a really nice guy and everybody wanted to work with him, and the competitor was a jerk, right? Believe it or not, that makes a big difference. But if you do this right, if you have a strategy in there, you can make IP more than just a checkbox, right? When I have clients that are doing their A and B rounds of funding, raising 10 million or more in a round, I'll actually do a PowerPoint slide for them, a cluster map, where um, uh, I can visually show the relationship between the key features of the invention and um, the patent portfolio in a kind of a spider web map showing with lines all over it, right? We call it a cluster map. I didn't invent it, but it's kind of cool, right? I'll do that slide for free for people, right? When they're at that stage and they have, 15 patents and patent applications and they're raising really big money, okay? That is a great way to convey to the investor the idea that the IP is more than just a checkbox. Yes, it's done. This actually fits in with the whole company's strategy. The reason you're investing is exactly the technologies that are covered by the IP, right? That raises your valuation, especially on an exit. Okay, so that's strategy. Now let's see. The last thing, click on my slide here. Okay. The last mistake is understanding the patent. And again, I give a whole hour-long talk on understanding the patent. If you reach out, I will send you the link to that talk. The patent gives you a right to exclude. It doesn't give you a right to do, right? So you might have a patent on your stuff, but somebody else might have a patent that's close that's going to prevent you from doing stuff, right? Um, you might have a patent on the bobbin on a sewing machine, but somebody else has a patent on a needle with a hole at the pointy end, right? So it doesn't give you the right to do something. It only gives you the right to exclude others, okay? Um, there's a difference between a public patent application publication and a patent, right? So sometimes clients will come to me and say, "Oh my gosh, look what just came out. My competitor got this patent." Blah, blah. And first thing I look at is, so that's their published application. It's not yet a patent. It may never be a patent, right? It's just a published application. And the next thing I say is, well, there's like 80 pages of description here that talk about all kinds of technologies, right? Some of which has been around for ages, but their claims are really, really narrow. Okay, it's the claims that you say what gets to be excluded, what the rights are. Okay, so a patent can have a specification that talks about lots of stuff, but the claims can be extremely narrow. All right, the claims are what define the invention, right? And if you do everything that's in a claim, you probably infringe that claim, right? The claim may be invalid, but before it's shown to be invalid, you might infringe it. If there's a claim that has a bunch of stuff in it, and you do half of those things, you don't infringe, right? So a narrow claim is one that has a lot of limitations in it. A broad claim is one that has only a few limitations. Sometimes I have people come to me and say, "Oh my gosh, I got this fantastic patent. It was really cheap. I had this guy in Minneapolis do it, and he's like a patent agent, and it only cost me a little bit." And I look at it and I go, "Oh my God, right?" The first claim is a page and a half long. It's like, yeah, the prospective clients, yeah, I want to sue everybody on this. It has got everything I do in it. And it's like, well, you know what? Somebody would have to really, really work hard to infringe this because they have to do every line here, every element of this claim in order to infringe. And the guy said, well, what do you mean? I said, if they miss one little element here, they're not infringing, right? It would be almost impossible to infringe this claim, right? And they're flabbergasted. Well, what happened, right? And I learned more about what they've done, and they paid somebody who um, just took their money, right? Not a a proper startup attorney, right? So understanding what the patent does. Um, I do about 5 or 10% of my practice is patent litigation. A typical budget for litigation is in the millions of dollars, right? 2 or 3 million isn't unheard of, right? It takes years. So if you are a startup and you find yourself in patent litigation, you probably are turning it into a patent enforcement company rather than a startup building products because it will consume you, right? Your goal, your purpose of developing patents is so that you can get a great exit and the value of your company is increased. It's not going to be to spend millions of dollars going after infringers, right, and your competitors. Let the big multinational that acquires you do that, okay? Because um, until you have, you know, annual revenue in $100 million, you don't want to, and up, you don't want to be engaging in patent litigation, right? Okay, so that's it. I got a couple more slides that we're going to just cover some other points here. Again, right? Why would you do this? Why would a cash startup put thousands of dollars into developing an IP portfolio? Okay, do you have the answer? Right, valuation. You want to increase your valuation. My goal as a patent strategy is so that when this video happens, right, you're the little white thing floating there, and that's your acquirer coming after you, right? Is he going to have you for lunch, right? Hey, little guy, I'm hungry, zoom, right? You know the next thing that happens in the movie, right? Okay, so the IP portfolio is supposed to protect you and make them pay to have you for lunch, right? So you go away happy, right? If I do my job right, I pay for myself 10, 100 times over. Okay. So that's the goal, all right? And, a lot of companies say, what should we do? Why should we do patents? Does it really matter? I talked to somebody who said patents are useless. They're hard to enforce, blah, blah, blah. Well, they are, but your acquirer will be able to spend plenty of money enforcing them. And in the meantime, you will have more money in your pocket, all right? So the goal of patents is to make you richer, right? Make your company happy, make your investors happier and richer, right? That's my goal. All right. I've been talking mostly about patents, but there's definitely other types of IP. I've just got a few more slides. How much time do I have left? Checking time. Okay. What can you get? All right. There's things other than patents. There's copyright. Copyright covers like a photograph, a bunch of text, software code, a wonderful painting, right? So for example, a copyright would cover a specific painting of a bunch of fruit, right, in a bowl. Right? A copyright doesn't cover the general concept of, oh, hey, I'm going to put a bunch of fruit in a bowl and paint it, right? It only covers that specific example. Copyright will cover code, right? It will cover the version of code uh, written in Java, right? But if somebody takes the code and kind of redesigns it and then writes it in Python to do exactly the same thing, that doesn't get covered by that copyright, right? If somebody writes a book about a big white whale, right? The words of that book are covered by the copyright, but somebody else could go and write a book about a big white whale as long as they didn't use the same sentences, right? Right. Um, so if you're a software company, put a copyright statement in your executable code and everywhere else. Put a copyright statement on your website. Okay, the text of your website, the layout of your website can be copyrighted. The photographs on your website could be copyrighted, right? And you made sure that those photographs you have license to use, correct? Right? Go ahead and pay Getty Images a few bucks so that you can get a image and get a license to use an image, right? Um, Trade secrets are very important. They can be critical. You sometimes hear about a giant litigation between trade secrets, um, between big companies over trade secrets. Trade secrets don't cost very much, right? You don't have to hire an attorney to file them with the patent office, but they are best documented, right? So if you're going to develop a trade secret portfolio, talk to your IP attorney and say, what should we do? And that attorney should say, okay, I want you to write up a one-page description of each of your trade secrets. I want you to track who has the rights to it. I want you to create actually barriers so that everybody in the company doesn't have access to those trade secrets, right? Only a select people do, few. When you give somebody access to a trade secret, you have them sign off that they're getting access to something and it's a trade secret, right? When they leave the company, you remind them, yes, you signed off on these 3 trade secrets. I always feel sorry for the engineer that does something and 7, 8 years later, they're going, oh yeah, how did we do that at the, 2 jobs ago? Oh yeah, boom, 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 boom. We had this great algorithm and boom, boom, and they use it again. Well, it's a trade secret, okay? They're not going to remember unless you actually have a program and you tell them, hey, this is a trade secret. Otherwise, their arguments are, everybody knew about it. The sales guys talked about it all the time. It's not a trade secret. You never indicated to anybody it's a trade secret. How are we to know, right? Um, that's expensive trade secret litigation, right? It's much better if you have a program. Here are the 10 trade secrets. It starts with our product pipeline, our roadmap, our sales prospects, our marketing strategy. Then we have engineering ideas, things that you've decided not to patent, right? Technology advances, how your neural network is programmed. Those are all trade secrets, right? The weightings in your neural networks. Okay, document those as a trade secret, have a program, keep really good records about what your trade secrets are, okay? Put a program in place. It costs you a few hours of your time and it can be hugely valuable, right? When you're being acquired, um, then somewhere deep in the due diligence, you'll list your trade secrets, and when the sale goes through, you'll show it, right? You'll transfer it. Okay, so they can be valuable. And I've already talked a lot about patents. Patents are useful, and they can really impact your valuation. All right, I'll talk a little more about patents. What can you get? This is like almost my last slide. So bear with me for just one more minute. Uh, Provisional applications. There's no such thing as a provisional patent. It's a provisional application. It's quick and dirty. There's not a lot of technical requirements, right? So you can take a PowerPoint, you can take your pitch and a requirements document and a bunch of notes that you guys have put together and put a cover sheet on it and file it as a provisional application. That gives you the rights of a filing date for what's in that application, right? It's quick and easy, inexpensive. It only lasts 1 year. Within the year, you need to file a non-provisional application of some sort that claims benefit of that provisional. If you don't do that, the provisional goes away. It never gets published. It's as if it never got filed, right? The non-provisional is what could turn into a patent after a few years, 1 to 4 more years or whatever. It gives you 20 years of patent protection from its filing date, right, which could now be a year after the provisional. It costs a lot more, you know, 15, 20,000 just to get on file, right? It's a much more formal document. When I do work with early stage startups, we usually start off with provisional applications. And at the end of the first year, we file at least one non-provisional claiming benefit of all the provisionals, right? That same deadline applies to filing outside the United States, foreign filing options. So that's um, another deadline that'll be coming up, right? All these things cost more money. A great scenario is you file your provisionals, you raise a bunch of money. By the end of the first year, you can afford to hire a patent attorney to do the full project. And then you start filing non-provisional applications. I will do a provisional with early stage startup on a tight budget, 2,500, 3,000 maybe. And the goal there is for me to work with them to write some claims, beef up the provisional so we know that it at least has enough stuff in it to make it valuable, right? We've discussed at least a little bit all the important technology, right? All the things that we might want to have in claims in a later patent application, right? There's also design, there's a bunch of other types of patents. There's plant patents, there's patents on semiconductor masks and so on. The only other one that I commonly see in early stage startups is a design application. These can be useful. Technically, a design application is supposed to cover the ornamental design of something, the shape of it. So, for example, my favorite design application is the Polycom speakerphone, right? It used to be that I would have lots of client meetings in a conference room and there would be a speakerphone on the desk and I could point to it and say, see that nice, cool triangular shape? Well, that was the subject of a very valuable design patent that Polycom got. And it turned out to be very important because kind of the alternative designs are squares or big circle things look like flying saucers. Having the speaker in the middle pointed up and the microphones around the edge turned out to be useful. So Polycom enforced that patent. They litigated that. The cool triangular shape actually sold product. Okay, it's moderate costs, mainly drawings, and it only lasts for 14 years. All right, that's it. Last slide here. Okay, we're actually only in 12 countries now. We pulled out of Russia. Here is my email address. Please connect with me on LinkedIn. If you reach out, I will send you the link to the Understanding the Patent webinar. And let's see, anything else? I'm now going to go and find the chat. So give me a second. Hold on, I got to switch glasses. Yeah, because I can't read my text. There we go. Oh, now I can see. Okay. Great, we're going to go find that. Q&A. Boom. Good, we have some reasonable questions here. I'm going to go through 5 questions here in the Q&A. If your startup employs someone, how to make sure that the people's IP transferred to the company? Will that change if the person is full-time or contract or a service provider? So a service provider like an engineering company won't be able to do a blanket IP assignment. Typically, their agreement will focus on the specific project defined by a requirements definition for their project, right? There'll be some document about what they're going to do and your ability to capture everything they're doing because they're working for other people too, right? You can't get everything they want. This also depends a lot on what state you're in, what the state the employee is in. If they are in Florida or California, the scope of what you can capture is completely different. I'm a California attorney, right? California is pretty employee friendly. In Florida, you can have an employment agreement that says any invention. My understanding of Florida law, right? So that means that if the guy invents a new lawnmower and you're actually in the um, uh, wearable watch space, right? The company can claim the lawnmower, right? In California, anything the company grabs has to at least be tied to their business. Although I have seen companies say, "Oh, you started something in robotics, and we're a television manufacturer, but we use robots to build our TVs, so that's our space, right?" So litigations. Okay. Um, there's specific language that should be in all the employment agreements and the contracting agreements to cover um, transfer of the IP to the company, right? And a patent attorney should look at that language, make sure it's good. And again, if the contractor, they may or may not be willing to sign the same bucket. I often look over agreements for both individuals and for uh, companies, and usually they can find good ground. Okay. Somebody's asking what is a gay? I don't know. Cheerful. Okay. Can I record meetings on my phone or tape recorder? Yes, you can record the meeting. Um, this is being recorded and the recording will be sent out to everybody. I will share that recording with attendees. Um, narrow versus broad claims. Here's a real question. Um, uh, the so to get a claim, to get a patent with a claim in it, the claim has to be new and non-obvious of everything that came before. So the patent office is to gatekeep this. When you apply for a patent application, you have a set of claims and you send them in with the specification, which is the description, plus the claims and some drawings and other stuff, right? And the examiner looks at that and says, oh, your claims are all anticipated by this, this, and this, or by this, right? And then you have to, 95+% of the time, there's rejection on the first time. You have to either amend the claims to avoid the prior art that the examiner has found, or you have to argue that the examiner is wrong, which is usually a combination of both. And if you can get a claim and the examiner can't find everything in your claim, either as part of a one source or a combination of sources, obvious combination of sources, then that claim should be allowable, right? So there's got to be at least one thing unique in that claim, one special thing about it. Then the patent issues, and now you're talking about what's infringing, okay? To infringe, something has to do everything in that claim. If it's a system claim, then some product has to have every element of that claim. If it's a method claim, then there's a method with a bunch of steps in it. Every step has to be included. So if I see a patent from somebody else and my client is worried about it, and I say, but you don't do that step 3, right? And they say, oh, no, we'd never do that. They don't infringe because they've avoided one of the limitations. It's kind of the opposite of what you have to do when you're applying for the patent. Okay. So on the infringement side, now a broad claim is one that has very few limitations. Okay. It's not strictly the number, like in a chemical compound in a plastic, it could have one limitation, but it's a specific chemical formula with very little wiggle room, which is that's narrow with only one element. But if I look at a patent and I see a whole page, a whole column in an issued patent that's like claim one, it's like I don't even need to read it. It's going, oh my gosh, how yeah, my client, we just need to go through there and find something that's not, they don't do, or they could engineer around and avoid doing, and boom, they don't infringe that claim, right? Uh, so that's that's the difference between narrow and broad, right? Uh, in a patent, you'll see an independent claim. Claim one will also be an independent claim. And then claim two might say the system of claim one plus this, blah, 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 right? So that's adding another limitation. That makes it saying claim one, but a little bit narrower. So you have dependent claims that are narrower than your independent claims. And in a typical patent, you'll have a whole range. So someday, if the patent's litigated, fought about, the independent claim might be knocked out. Somebody might find prior art against that claim. Here's some publication from uh, Brazil and some student's master's thesis that had everything in your claim in it, and it was published before you filed your patent application, right? That is prior art that would knock out your claim one and make it invalid. But claim two and claim 13 might still be good, right? That's why you have a whole range of different claims in a patent application. And one of the goals of a good patent attorney is to claim things orthogonally, meaning from different directions. So I gave the example of a sewing machine earlier. Um, the bobbin was a huge invention. That's the thing in the bottom that feeds the thread up. But a needle with a hole at the pointed end would still be a great claim to cover the sewing machine, right? Uh, Nobody in their right mind would put the hole at the pointed end of the needle. They would always put it at the flat end, at the fat end. Sorry. So um, that's the that's a non-obvious thing. It's something really simple. Engineering wise, it's a no-brainer. But half the time, inventing something is realizing the problem, right? And once you realize the problem was, oh, we want to put this thread down here, but if we have the hole on the fat end of the needle, that's not going to work. Um, so we're going to put the hole at the other end. It's not obvious because nobody would do it before, right? But now that you have the bobbin in combination with the needle, it makes sense to put the hole at the pointed end. So this is the type of thing like a good patent attorney will say, okay, you're now doing this way. Nobody would have done that before. And you're now, well, that's obvious. And so well, it was only obvious after you realized the problem that you're trying to solve that nobody even realized existed yet. Okay. So and that it's also blocking. In other words, it's something really simple. I mean, I know I'm getting off track here, but it's something really simple, but it owns the sewing machine, right? I mean, without putting the hole there, you can't do it. Okay. Um, so, can you help protect IP? Yes, I can do stuff. I work, so my clients do filing. I work with patent law firms all over the world. As a U.S. patent attorney, um, I do a lot of filings, and in one of my clients is Facebook. So um, most of my clients, almost all, 99% of my clients are early stage startups, but there's a couple of that have, I started that way and they've grown. Um, I work with foreign associates all over the world, right? I have a network in Asia and in Europe and in Africa and um, uh, all over. So if you were a company based in India, I would refer you first to an Indian patent attorney. Um, and because if you're a US company, I wouldn't refer you to an Indian patent. There's all kinds of reasons why that doesn't work. There's export issues and technology transfer issues and so on. If you can get a good patent attorney in India, it's probably going to be a lot less expensive than me, right? And I'm a Silicon Valley. You can even go to Minnesota and get somebody less expensive than me. Um, but you're not going to get somebody who's focused on early stage startups like I am, right? Getting hiring a patent attorney is like buying a car. You can get a Yugo for a few $1,000s and it'll run a few thousand miles, right, in the die. You can get a Camry for 25,000 maybe. I don't know. I bought one lately, 30,000, and it will go on forever, run a million miles, be the greatest deal in the world. It used to be that I would give this analogy. The next step would be Jaguar, but Jaguar got bought by a much better engineering company than Jaguar was. And they're now getting much better. I used to say, and then you could buy a Jaguar for 70,000, and it would also be a disaster, right? So there's not a direct relationship, but you want to hire a patent attorney that's worked in your field, that's been, has at least 10 years experience, works on the type of company you are, right? Will work in a budget for that's works for you, right? Patents can be done on a budget, right? You shouldn't get surprises from patent attorneys. Other types of law, it's much harder to do, right? If you're divorced, you might start with a budget, but it can get blown, right? So um, if you're let's just say, a startup based in India, I'm probably going to suggest you start with an Indian patent attorney. Same with Korea. I have some great firms in Europe and in England. Um, so that's, yeah, but I do file first in the US and then from a US application going out all over the world, probably probably at least once a week. Okay. Um, and the other thing I can do is help you get a presence. So again, Ramon, we are relatively inexpensive. We're about a third of a big law firm cost of an equivalent law firm because we don't have expensive offices. So I'm associated with our office in Truckee or in Lake Tahoe and our office in Menlo Park. I go into those like once every 6 months, right, to meet with a client in a conference room. Most of the stuff. Otherwise, I'm working usually in Reno at home, um, and which is wonderful, right? The coffee is always fresh. Yeah. Okay. Um, I'm blabbing. I'm sorry. Okay. Some trolls. Yeah, I had to shut down the chat. Sorry. Then, in all the years I've been doing this, it's the first time that's happened, but it happens. Okay. What is fair use? How is that complicated in the age of generated advice? So that's two questions. What time is it? Okay. I will have a hard stop at 1:30, but I'm getting some great questions here. Fair use relates to copyright, not patents. Okay. Um, so fair use example, the key example of fair use is a TV station that's doing a news report on the Oscars, and they use a clip from a movie. Okay, they don't have a license from the studio that made that movie, but it's a piece of news. Okay, so that's fair use of that movie. They can't show a 10-minute clip, right? But they can do a news story and say, here's the scene, right? Get an image from it. If I'm doing a news story out on the street and there's a billboard behind me with somebody's graphics, fair use is, hey, you put it up there and somebody's going to film, right? That's fair use. Okay. Um, Fair use is not taking a music video, posting it yourself on YouTube and trying to generate money from that. Okay. So that's what fair use is. And the big question now before us, and I'm not going to side one way or the other, is an AI company that scrapes the internet and grabs articles from the New York Times or my blog posts that I have a little copyright symbol on, is that fair use of my content to train their AI? And to train their eye, they need to scrape. They have a temporary copy of the material that they have on their server. They feed it to their AI. Boom. Was that fair use, right? And that's not been decided. Okay. That is something that will eventually, probably in the next 5 to 10 years, hit the Supreme Court. It will be a big deal. I am not even going to try to speculate um, where that's going to end up, right? We have attorneys at Ramon that specialize in copyright and in this fair use subject. So if you're going to use a material produced by others, whether it's a logo, so here, okay, Paris, Starbucks coffee, all right, this I've just used this in this video, okay? But that's incidental use, right? It's not like I'm putting this logo on my website, which in theory, Starbucks could have a complaint about. If it's a big name brand, if it's Louis Vuitton, they are aggressive, right? In my firm, we represent brands, right? We represent sports figures, right? If you are a major athlete, you might be represented by Ramon Law, and we do that type of work. Fair use of their name is an issue we will have attorneys. Now, back to the AI part. It's not clear yet what fair use. The first issue with AI is um, can you um, is it fair use to train an AI, right? And that's undecided, right? A lot of my clients are in the medical technology space, AI, med tech, and the big issues there is, did you have the rights to use this patient data, right? Oh, you got it from a university, right? The university foundation got it from their medical center. Did the doctor get the permission from the patient, right? We need to make sure it goes all the way back, right? That can be an issue. Uh, the other thing is now with generative AI, the patent office has said you can't copyright something that's generated by an AI. And it's also true that you can't patent something that's generated by an AI, right? Um, so here's the deal. So I wrote, 10 years ago, I saw an article about MIT that was doing new battery technologies, and they developed an AI to do that 10 years ago, right? And I'm looking at myself, shaking my head and thinking, oh my gosh, if I were an examiner, any battery patent that came out of MIT, I'm going to now question, right? Because if the AI came up with something that's listed in the claims, that invalidates the whole patent because, right, the AI can't be an inventor. You have an improper inventorship, and boom, patent's dead. You have to be really careful. It's if you take a painting, you paint something, and then you have it cleaned up by AI. What percentage of that is yours, and what percentage of that is the AI? Right? Well, there's no bright line, not yet established by the courts, right? So well, example. Okay, I have a 12-year-old daughter. She made this. Okay. Right? This was made by her. Okay, off a design she got off the web. If she now changes that, and now we take the image and we modify it using AI, and we make it a character in a video using Dolly, some AI program. It's very unclear what rights are can be copyrighted. All right, because this was a design off the web, right? Maybe she did the back a little bit different. Okay, sometimes she adds feet to it. She'll change stuff. So her own variation, potentially she could copyright if she did some fun design. But the fact she got the design off the web means, that overall it's probably not copyrightable unless she contributes something significantly to it, right? So there's a Campbell soup can, and there's a Campbell soup can as art by Andy Warhol, right? That was trademark issues, and was it? There's a phrase in copyright law called "is it transformative?" Right? Did he really change the can? And of course, that was fought over tremendously. Those are the issues. So there can be a lot of issues that come up with an AI. I have tried in some cases some really interesting tools. I have some really interesting tools for developing, and I'm keeping an eye on the time. Okay, for helping write patents. Okay, and the thing is, what if the AI comes up with some phrase or something that wasn't in the mind of the inventor, right? So it's kind of, you got to be really careful, and I'm very careful at introducing anything that's AI. What I've found most useful is I write a paragraph and then I ask the AI, not ChatGPT, a confidential, internal AI tool for patent attorneys, secure. um, how would I rewrite this paragraph? And then it gives me some examples, and I go, oh yeah, that sentence is better. It hasn't got to the point now where it will save me tons of time, but it's good at proofreading, right? What have I missed? Proofread my claims, so I've got some structural problems with them. Find problem. So, but it's coming. We will see the case but there's still a lot. A good example is I talked about how a patent application has to be related to the parts of your product or business that are really going to drive success, right? The AI is not going to be able to sit and figure that out. That's a discussion between humans. Okay. What is it that's going to make your product a success? How am I going to take those features and figure out what parts of your technology to cover in patents in order to protect those features? The AI is, I'll be long retired, right? 10 years, 20, 15 years from now, before that gets, an AI can do that type of stuff. So there's a lot of things that are useful. Okay, I think I covered Anonymous' question about generative AI. Okay, I have seen many videos of Take Me Home Country Roads, the song by John Denver. There are the written lyrics and different backgrounds of different videos posted by different YouTubers. The song's same, yeah, many. So it's the use of the lyrics is not probably fair use, right? The state of John Denver is probably getting a little money from the use of that lyrics. And if it's him singing it versus a cover, there might be a copyright on the lyrics and a copyright on the voice, on the singing. So I listen to a lot of Audible books, right? When I'm driving between San Francisco and Reno in particular. There's a copyright on the book, the text of the book. There's a copyright on the voice and the performance of the audiobook. There's a copyright on the video, on the image cover for that book, right? There might be a copyright on the background effects, right? So there's all these different levels of copyright and there's agreements that penetrate through all that. So if the family of John Denver objects, they can send a takedown order to YouTube, right? There can be a relationship where they're actually getting money for the lyrics. If it's John Denver's voice, also for him singing it, right? So Pandora or Apple Music, all these and there's tons of we have actually, Ramon has a big practice in the entertainment, both in sports and entertainment. We represent the Chicks, the former Dixie Chicks, a lot of famous jazz people, rock bands from the 70s and 80s, right? So they deal with all these types of agreements. Many of these videos have millions of views. Yeah, it's okay to do. So the first thing to do is try to get a license. And that will protect you from takedowns, right? And it's not expensive, right? Can I do that on YouTube with songs? Yeah, go to the agent of the artist and ask them. That's safer. And it's not, they might ask for a percentage of the revenue, right? But then you get to stay up and then you get to say to YouTube, no, this is licensed, blah, blah. Right? And in a particular case, where you're using parts of a song or a melody, then you got to talk to a copyright attorney, right? How much is too much? Okay. What if I have a patent and a competitor steals my secret sauce? How do I stop them? What if I do to stop them? Is it costly and time consuming to sue them? Yes. So I have a patent litigation case that is nearing its end. I'm hopefully in the next month or so, we'll have a close. In December, it'll be 9 years old. Okay. So this is exceptionally long, but it was very slow. It can take a long time. It can cost millions of dollars, right? If you have a great patent portfolio, there are companies that will fund your litigation for a percentage, and I have a list of those, right? I have one litigation ending, and I think 2 or 3 that are starting up that'll be started at the end of this year. At least one of those will have outside funding. The funding budget will be in the millions of dollars. And I've had this, somebody with a patent on a great garlic shredder, right? And he's in the home appliance business or the kitchen appliance business space, right? He comes to a trade show, he sees somebody's copied his product. He says, I have a patent. What can I do? And I said, well, just getting out the door, I would like to see a budget of between $250,000 and 50,000. How much do you sell of this thing a year? And he's like, I sell 50,000 this a year. It's like, well, there's no way it's going to pay, right? And that's set gross, right? Um, I have had I had a client a few years back, maybe 10 years ago, that litigated over a dog harness, and they spent about $250,000, and it was a cut and dry case, and that was considered really cheap. They won, and Petco and a couple of the other big pet stores pulled their products off the shelves, right? And it was more about the exclusivity of the product and the brand than it was the dollar and cents of the um, case. And at one point in the litigation, we're in front of a mediation, and the opposing counsel, who I knew pretty well, says to me, this doesn't make sense. Why are you fighting this? It's going to cost too much money. And I turned around in front of the mediator and said, and his clients, I said, well, you obviously don't understand my client. You're leading your client down the wrong path because it's more than money to my client, and we're going to nail you. It's going to cost you a lot more money. And I think that helped move us to settlement. They gave in. It wasn't worth their term to fight, their cost to fight, and now those patents are probably now expired. So, those dog harnesses are everywhere, I'm sure. Um, so, if a competitor steals, you can threaten, you risk litigation. That's a whole. This is a talk with a patent litigator or a patent attorney like me, who does some litigation. The pros and cons of approach of how to enforce, right? But if you are pitching your company to a seed stage, and you tell the investor asks, what about the competition? You don't say, oh, we have a provisional patent application filed. We don't have to worry about competition. That's the wrong answer. The provisional might be a patent in 3 or 4 years, and then it would take millions to enforce. The investor is not looking to invest in a patent enforcement company, right? Your answer to that question should be about your features and your market strategy and your first movers and the fact that your founders are experts in the field and all these other things. It's not that, oh, you can add that, someday we're going to be acquired for a lot of money because we're going to have a great patent portfolio, and you, investor, are going to make a lot of money. So it's costly to sue. Is having a moat, market dominance, first to market, barriers to entry, best protection for IP versus patent? Depends on your situation. Sometimes, I'll have somebody come to me and we look at what they're doing, and it's like, there doesn't look like great opportunities for patents here. There's a few things that we can do as a trade secret that's better off for you, and that's, a couple of hours of attorney time, getting some program in place. That's easy. Also things you can't discover, right? So if you're going to patent something that you can't see in somebody else's product, is something hidden inside. It's a way that they manufacture their clutch for a car, some thermal process. It's hard for you to identify if they're infringing or not. Then the patent's not really much good because you got to be able to figure out if they're infringing. Okay, so things that are hidden are good for you to be a trade secret because you can keep it as a trade secret because it's hidden. And that means that you can, and trade secrets can last for many, many years. But if somebody else comes up with it with the same way of anodizing the metal for your clutch, you're not going to be able to stop them. And the trade secret, and if they publish that, the trade secret's now out. It's no longer a valuable trade secret. But that's it. This is a case where the specific facts will really make a difference. A provisional patent could turn into a design patent, but there's restrictions on the timing. So you want to be really careful. This is something you should talk to your patent attorney about in detail. Yeah, it depends on the exact case. Are laws in other countries a lot different than US? Yes, they can be. So my clients patent all over the world. some people say, oh, China's not worthwhile, but I've seen cases where China really does become worthwhile. And the reason for that is um, I have seen a US company sue another US company in Chinese courts. Um, and the particular case I'm thinking of, the defendant was Texas Instruments, a big Texas printed circuit board maker. And they do most of their manufacturing in China. So getting threatened in a Chinese court under a Chinese patent by a small startup was very scary because if they lose, they're sunk, right? So it went to settlement pretty quickly. But that's a case of, right? Um, the discovery rules are different. The speed of the courts are different. Who pays is different. In Europe, the loser in the litigation pays everything, pays both sides the legal fees. Um, I've uh, um, the requirements for what's patentable varies between countries. I am again a U.S. patent attorney, a licensed attorney in California, but I defer to my European associates when we're dealing with, today, this afternoon, I'll probably be working on um, a patent having to do with extraction of interesting materials out of cannabis, right? And I'm making suggestions to the foreign associate, but the rules there are substantially different. So the foreign associate, he will be the one to make the final arguments before the European Patent Office, right? So that's part of the reason that foreign filings cost so much because you've got layers of attorneys. Right? So, okay. Tariffs are, yes, well, tariffs are definitely affecting my clients. um, I have one that on Liberation Day called me up and says, I have 10,000 baseball caps in a container that are going to arrive the next week in the Port of Long Beach, and my margins are much less than the tariffs that just got put on it, right? So we're going to dump that car. We're going to lose $34,000 for a small two-person company, right? It was a big deal. And of course, those caps were going to get embroidered by my client, and then that was going to be used to fulfill an order for the state of California's Caltrans transportation agency. It wasn't going to happen, right? So a lot of my clients can't even take orders now for goods because the raw materials are going to come from overseas and they don't know what the cost of the raw materials are. So it's not a matter of the tariffs causing inflation so much as it is they can't even do business. Um, our tariffs, so other things. I have clients in e-commerce. I actually spoke with one this morning on a call, and that client is specialist in drop shipping. So at first, the new tariffs and the uncertainty were a big blow to them, but that's turned around now because Chinese companies are now interested in having materials in the US that they can drop ship into the US, so there's no tariff. And where we had the de minimis rule, sorry, 4 minutes left, I promise to end, where they had the de minimis rule of anything under 800 you don't have to pay a tariff on, which meant they could send lots of sneakers without tariffs. Now it turns out it's better for them to send a container, get that delivered, and then drop shipped from the US. So there's actually different business models that companies are doing, but it hasn't really impacted too much the uh, patent realm yet. But I think in that client in particular, we probably will tweak some patent claims in the next 2 years, depending on how the business model changes. But that's why it's important to have a patent attorney who understands your business, right? And I spent, again, most of the 90s as a CTO doing product development. I love that. I love trade shows. I go to CES every year. If you want to meet me in person, I'll be at CES in Las Vegas in January. What do you charge by the hour or by a project? I always work on a budget, a provisional application where I work with you, and I have 3 minutes, where I work with you and I'll do an outline and the claims and maybe some drawings, and you do most of the writing. We might work on a set budget of maybe $3,000. Okay, and we'll get a really good meaty provisional file that we know is going to support a non-provisional later and work well, be valuable. My billing rate right now is $7.50 an hour. Um, but usually I'm working on a per fixed fee basis. So for a patent application, I can charge by the page. It takes me 1 hour, it turns out, to have a double-spaced page done, ready to file. And so I just can, I love charging by the page because that means if I'm helping my daughter with homework or if I'm watching a ball game and I'm working at the same time, I don't have to figure out, oh, I was kind of lurking 30% of I just count pages when I'm ready to file and charge accordingly. But the key is doing, so most early stage startups will start off with a 2 or 3 provisionals over a year. And then if they've raised money, we do a non-provisional. If they haven't raised money, we discuss budgets and figure out what to do. But do I take payments? Sometimes. Depends. You know, I'm not too, I like working with individual. I like working with startups because I can be a big fish in their little bowl. I will review for free your pitch deck. Uh, I will, depending on your product and your business, I will suggest angel groups to talk to and stuff like that. So I do also work for a VC firm, by the way, just so you know. Can you work with clients 100%? Yeah, most of the clients I work are virtual. Many of them I've met in person, but I have clients. I have a client in Oklahoma that I worked with. Yeah, I mean, I have clients that I've worked with for 25 years now, um, and I haven't seen them in a decade, and I consider them good friends, right? I have clients that I go skiing with. Um, So I meet at other events and so on. Let's see. If we do many products, no. The question is, if we do many products, do we need to get each one patented? Will they be very expensive if we have lots of products? Yeah, no, you want to strategize. And again, a patent attorney who just says, all I do is patents is not what you want. You want a patent attorney who will work with your business and set the budget. So if there's some feature that's found in a bunch of different products, maybe that's more efficient. It might be that you um, do a patent on 3 or 4 of them, but we got to figure out there's some strategy, and the person you need to sit down with your patent attorney and strategize. Strategy was what, number 4? This is part of strategy. You got to figure that out. You don't want to go everywhere. You don't want to go to every country in the world. I have people who say, yeah, I want a patent everywhere. Well, great. Send me $4 million. Yeah. Okay. It's expensive. Do I work for equity? I have been known to work for equity. There's a specific way that has to be handled to make it nice for the IRS and everybody. Um, Generally, it's not worth doing that for provisionals because the paperwork versus the $3,000 I might do on a flat fee for provisional, that's kind of equivalent time and work and effort. Um, but it can happen. Probably once a year. So I might bring in 20 new clients in a year, and actually do work for equity in one of them. So you have to be pretty, and I do angel investments. So you have to be attractive to me as an angel investment in order for me to do work for equity. And that's pretty high bar. Okay, we are at time. I want to thank you all. Um, Please reach out to me. My email is there, and connect with me on LinkedIn. And again, if you send me an email and ask for the link to how to understand the patents, I will send it to you. It's available on YouTube, but I will actually send it to you so you can find it easily. Thank you very much, and this will end the recording. Okay. Stop.